Gentlemen, are there matters that we need to take up before we proceed?
Yes, Your Honor. I know this is the state's chance to do rebuttal evidence, but I think that it may be appropriate for us to have some type of preview because there will be probably battles about whether it's appropriate for rebuttal evidence or not. And I know there's some significant case law and things about what to do rebuttal or not. And I have some idea, but not total idea what they're planning to do.
I'll be glad to tell you now that we've had any forecasts about what their evidence would be, but I have the defendant's former post-release supervision officer here who supervised him once he was released from prison, the Wake County Detention captain who testified earlier to talk about his infractions in the jail, and we have provided to the defense this morning some Twitter information from Christina Love, the defendant's sister, who was posting on social media last night and would submit, obviously it's self-authenticating because she has a picture of her outside the courthouse wearing exactly what she was wearing yesterday and making comments about the trial. So that's our forecast.
All right, Mr. Brown.
I think we've had a ruling earlier on the court concerning post-trial release, that there is some relevance to that. The court has ruled, I think, over an objection on that. We maintain the objection of that, so I do think that some relevance, I don't know the exact extent of their evidence, would be relevant. The fact that he was on post-release supervision, perhaps the circumstances surrounding why he got off of, why he was no longer in compliance with it, would be consistent with the court's rulings with it. I would submit that nothing else would be. I would be objecting at this point to anything that would be coming out from the jail behavior and trying to figure out exactly what they're arguing the rebuttal is. I would point out that we have offered no evidence about good jail adjustment and good prison adjustment, which I think is what normally releases to it and all. There is, if they're saying that we opened it up based on F1, I would, as a rebuttal to that, I would turn the court's attention, and I'm sorry, I'm pretty sure this is the correct site. There's two State v. Coffees, but State v. Coffee 336 NC 412 1994 that talks about that post-crime conduct cannot be a rebuttal to that factor. And I certainly want to be heard on the Twitter feed that they're going to be talking about with it.
Go ahead.
On that. Well, if I may, if we may bring a copy and show that to you. We only have one copy.
All right.
Ourselves. Oh, that's the one? Okay. And that's the one, the only plan to show you.
Yeah, that's purple.
Okay.
Yes. Thank you.
Yeah. Argue that, first of all, citizens you have a right to pick names or anything else, and not think about how. But I think even having the name that's on there, which I could put, for the record, is prejudicial. I would argue, I understand we're not under the strict rules of evidence, but equivalent to 403, and sort of an invasion of I don't know, invasion of privacy, but just seems to be going into areas that might heighten the prejudice of the jury as it references private matters with it and all. I am worried. I think always writing for Baby Bro, I can understand, I'm ready for Baby to get off. I think we understand what her meaning is. It's not getting off in terms of getting home, but we're now in the fact that could be a prejudicial thing to the jury and getting the impression that this is not, we know that the decision right now is between life without parole and him never getting out and the death penalty. And we're risking that entering the realm of the jury, that we're talking about the possibility of somebody going home here. And I don't think there's any reason for that part to be included in it. would be going to, for issues of credibility with it and all. With it. So I would argue that at the very least, this needs to be seriously redacted, and we would object to the whole thing with it, on it.
All right. Ms. Shakita, let's start with the Twitter feed, and then we'll move on to the issues relating to post-release supervision and jail conduct. All right, Mr. Waller.
Yes, sir. Thank you. Good morning. Your Honor, I agree with Mr. Brown that this does go towards her motive and credibility. As you saw on the witness stand yesterday, Ms. Love appeared to be upset as to the situation that she was in, crying and whatnot, but then she gets off the witness stand and she makes a comment, "Everyone keeps hitting my line telling me I'm on the news like I wasn't aware." And then there are the letters LMFAOOO, and I would submit to Your Honor, and excuse my language, but that would stand for laugh my fucking ass off. Quite different than what she appeared here on the witness stand yesterday. As to her name, that's the name that she chose to put on her Twitter feed. And in regards to the privacy issue, once you put this stuff out on Twitter once you put this out on Twitter, it is in the public domain. She made these comments for everyone to hear. You can clearly see it's her out in front of the courthouse. And then the reason why we were able to find out that she was posting in this way is, if you'll see, I believe on the second page, or the second page in which I have, you see her there outside the courthouse, again smiling, which I would show goes to her credibility. And then it's hashtag Travion Smith trial. So from my limited understanding of Twitter, if you hashtag that, it puts it in a sort of like a feed where other people can read about what you're posting about. Other people can use that hashtag as well, and essentially go along with a blog or a public discussion. So she put this out there herself. She voluntarily put this in the public domain, and certainly the comments, her photographs, go directly to her credibility in terms of what her motive was for testifying yesterday. So I would ask that you allow it. We would be calling our intern, Miss Grace McGovern, who was following this on Twitter and saw the hashtag, and would be the one that we would call to testify.
All right. Anything further, Mr. Brown, on this?
Again, I would argue it's one thing you're putting on Twitter, which is everybody's right to do, but again, I think about putting the name in it in front of the jury when it is raising the possibility of rising to prejudicial parts about it. I think that any opinion exactly of what initials would stand for, I think that should be left totally to the province of the jury, and I certainly don't have expertise about that, and unless we get somebody to specifically say what the expertise is and about it, what those initials were about it. There's some that I do know what things mean. I did not know that particular one about it, so I object to that. And so I would argue at the very least, I think that there's no reason for that particular name to be up there and all. I think it's prejudicial. And I really...
Are you talking about... I'm sorry, I'm not a Twitter devotee, but sapiosexual,
yes,
at impaired DX logic, the entire name, or just the sapiosexual portion of that?
First part, sapiosexual.
All right.
I would say the whole name, actually, but especially the sapiosexual.
All right. I'm going to allow testimony about this. I will ask that the name be redacted. I think that's probative value of that is nil, and it has perhaps a slight prejudicial value, but undue prejudice. But the balance of it, I think, is probative of credibility and bias. I would also, if the witness has a lay opinion about what, if the witness is familiar with abbreviations or terminology that's used on Twitter and other social media sites and has a lay opinion about that based upon what she sees here, then I think that would be competent lay opinion that would be helpful to the jury. So I would allow that if there is such knowledge. Now let's turn to the so just clarified. I'd ask that if you could just with the black marker something redact that whatever works. Just the word sapiosexual is the only thing that I would say is unduly prejudicial, or that its undue prejudice outweighs any probative value.
Your Honor, I think that the other is just some sort of domain name, but it does, I don't know that all the jurors will know that. A lot of them are older, and I don't think are much on Twitter themselves. And to me, impaired logic means impaired, like by substance abuse impaired.
All right, that's fine. Ms. Shakita, if you'd go ahead and just strike the entire name. All right, turning to the probation supervision, I do think that, as I forecast in a prior ruling, the fact that Mr. Smith was on post-release supervision has become relevant. I assume that the state is going to elicit testimony about conduct or infractions or potential violations or things of that sort, observations that were made during this period of time.
To include comments about gangs.
All right. I do think that the defense has certainly put at issue the home life of Mr. Smith, the father's behavior as his role as a parent, his treatment of Mr. Smith, and my limited awareness of what is contained in post-release supervision files from having reviewed some of those in camera is that is a perfectly reasonable area for the state to cover in terms of an alternative explanation of why some of the discord and acrimony that existed in the household might have existed. So I do think that has been put at issue. I do not see this as character evidence, but rather there was a great deal of evidence put on about the father and his motivation and his parenting skills. And so to the extent that this relates to home life and difficulties that existed within the home, it's certainly probative there. Are there other areas that you intend to offer it for beyond sort of describing?
The only other thing I think is a positive marijuana test. That's the only issue. And then the issue about being kicked out of the home and what the concern was there.
Right. Yeah. And well, I think being kicked out of the home
life as well.
Right. And how is the positive marijuana test probative? Is that something the father was aware of? And
no, I mean that's the only other thing contained within the file.
All right. How is that? What's that probative of in terms of rebuttal?
Well, in terms of, I would say that this goes more to the character issue, which the state would maintain they put into evidence yesterday by asking witness after witness after witness whether he was respectful, whether he followed the rules, whether he was tried to please the authority figures in his life. And I would submit to you that that was one of the rules that was laid out for him, and he was in violation of that rule. And it's one of the reasons that also prompted him going from regular post-release supervision to electronic house arrest. So I would submit it's part of his following the rules and being respectful as well. Whatever the court says.
All right. And then you also mentioned that, and I know the records do contain references to gang activity. That, as I recall from the records, that's in the context of the father being concerned
Yes.
about who Mr. Smith was hanging out
Yes.
with, that sort of thing.
Before he came to this particular officer, and then during the course of that, was very concerned about getting back into trouble again. And again, he has been thrown under the proverbial bus throughout the course of this trial. And so I would submit that Officer Shellhorn's observations and the interactions with the father would be to rebut those things.
All right. Mr. Brown, you wish to be heard further?
I think that they have not laid a strong enough foundation for the putting in the marijuana, the drug test with that. I think that the information about the gang activity, I realize that there are some that has already come before the court, but I don't think there's anything particularly from the evidence that has come beforehand. We would also argue that statements that are made about the gang life now would invoke confrontation and hearsay concerns, which do apply to, this confrontation clearly applies to
Right.
And Judge Alfred mentioned that the defendant in his interview admitted to smoking marijuana on the day that he was arrested for these offenses. Yeah. Well, and there was corroboration of that, but his own admission to smoking marijuana on the day this happened. I'm sorry, the day he was arrested. I think he even said I had been smoking that day when he was talking about the 14th, the 13th into the 14th as well. So there was evidence that came out.
Yes, Misty?
I would argue goes to the fact that there's no need to rebut anything. We haven't denied. He didn't deny, and we haven't made any, there's been no evidence in this that he was living a drug-free life.
And they can't, the argument we would say is rebuttal, for the purposes of it is to rebut our evidence. They put in the evidence that he was smoking marijuana. We didn't do anything with that evidence. They can't then use the rebuttal stage to say, yes, indeed, he was smoking marijuana.
And I just say that it goes to him being able to follow the rules and being respectful of the people with whom he was trying to help him.
All right. I think that the marijuana smoking has limited probative value. I know that rule following is a theme, but I don't think that it's, it's clear that rules at school were not followed. And I'm not sure that that was the thrust of the defense's mitigation evidence. So I think that with respect to post-release supervision evidence that relates to concerns that the father had, difficulties in the home that the post-release supervision officer is aware of, and that would include the gang activity, that is all permitted. All right. So I think except for the positive marijuana tests, and that was one of the basis for increasing his level of supervision, I think that would be the only thing I would exclude from the forecast you've given me thus far.
Yes, sir.
All right. Let's turn to the jail conduct, post-arrest conduct. What's the probative, for what purpose is that being offered?
Again, Judge, there was several witnesses yesterday. I believe that the defense has opened up the door to the defendant's good conduct, and the state is allowed to rebut his bad character. The testimony that the state would seek to elicit from Captain Steinbeck is that while he was in the Wake County Jail, that on several occasions, specifically 3, he was put on lockdown for disobeying orders. Once he was refused to obey and pepper sprayed, again, a disobedient sort of action. He made disrespectful comments to female sergeants and was put on lockdown. And specifically in June of 2015, he got into a fight and an altercation with another inmate and got 50 days of segregation for those things. Again, witness after witness was asked, have you ever seen him be aggressive? Have you ever seen him, has he ever been disrespectful? And this testimony would go specifically to combat that.
Mr. Brown.
We would have 2 objections to that. First of all, I think it's relevant to what they're exactly is that we have not offered any evidence about post-arrest behavior, and I cite the court, I think it's, and I have to say, I have not looked at this case recently, but my memory of it is State v. Coffey, 336 NC 412, 1994. I'm hoping I'm talking about the right Coffey. There are two of them. But that talks about not having post-crime offense as relevant to it. The second is I would object to, unless this officer has specific witnessing of these events, that this is a confrontation problem. Simply reading off the record what other officers may have found and everything else is a violation of the Confrontation Clause, as it's now been interpreted in State v. Crawford and other cases before it that talk about different records and on. There's one in particular out of Massachusetts. Its name is escaping me right now. But I think that, again, confrontation issues apply at sentencing, and simply having officers who don't have specific, now I don't know that for a fact. She may be the one who witnessed this misconduct, but I believe she is the record custodian, and therefore we would object very strongly to the reading of the records, and that the hearsay rules that would allow this type of business records do not accept for it at all, because these are things done for the purposes of testimonial evidence. Yeah, if I'm wrong about that she is actually a witness of it, I still think it's not admissible, but that's one of our objections to it.
What does the state say about the hearsay objection?
It is a business record. It's kept in the ordinary course of business. She is the custodian, and it is her duty to maintain, I can't remember if she said the safety of the jail, but all of the records and all of the inmates' complaints. And I would submit that that is the appropriate way to get these matters into evidence under the hearsay objection, I'm sorry, exception, not objection. And, you know, in the sentencing hearing, even Your Honor said that the formal rules of evidence do not apply. What his punishment was is something that is kept in the ordinary course of business and is not hearsay.
Clearly, the rules of evidence do not apply, but the Confrontation Clause absolutely applies. State v. Nobles.
So that he was put on 50 days lockdown for engaging in a fight is not testimonial in any way. It is a business record. It is his disciplinary record. I'd be glad to stay away from the specifics if the court would like that, considers that an issue, but what his jail log is in terms of his punishment for a reason. Clearly, business records kept in the ordinary course of business and do not involve testimony. I'm just reading that copy.
Just would like to also point out that that a mere recitation of what his infractions findings were and what his term of segregation was for each of those infractions, I think would sort of hamstring us. So, for instance, in one of the instances when the charges by the staff are more than what he's actually found to have violated. And there is sort of a history of the same corrections officer being involved in that in a prior incident, and there being carryover from that, and sort of what it specifically it's alleged that he said that caused that infraction to be heard. I mean, I think once it comes in, then I think, you know, he's entitled for the jury to know a little bit more about it, and so and then that's what opens up the confrontation issue, because then it's the credibility of the person with whom he actually had the conflict is obviously implicated by that whole conversation.
That's my concern. I think that goes closer to my concern with it is that assuming that your witness does not have personal knowledge of these incidents, that the mere fact that he has infractions on his record in and of itself is not probative of aggression or any other thing that's relevant right now. I mean, it could be that he was acting in complete self-defense, and that according to the rules of the jail, anyone involved in a fight gets segregation, whether you're in self-defense or otherwise. And so in that scenario, it would not be probative of aggression. Now, it may well be a probative of aggression. But I think that the problem is that merely because there were disciplinary violations is not probative of the fact that he was aggressive or any violent, things of that sort. So without that personal knowledge, to be able, without a witness who can come in here and say, this is what I observed, and then be subject to cross-examination by the defense, I think that the records themselves would not be admissible. Now, if that person is available and can say, this is what I observed, and Mr. Smith was the aggressor, and this is what happened, and I came and broke it up, and I then wrote him up, and then he was given 50 days segregation, that may be a different scenario. Then I think we have an opportunity for cross-examination. It is probative. I think that certainly one of the themes of the mitigating evidence put on by the defense is a lack of aggressive conduct. So I think that would be probative. But short of that, I think the records just in and of themselves would just lead to speculation by the jury as to what the circumstances were in that incident.
One of those individuals is working today, and the other one we believe is available. So if we may ask the court for a little leeway in terms of getting individuals here based on that ruling, but we're working on it.
All right, Ms. D.
If those issues that involve conflicts with other inmates are going to be at issue in this trial, I think that we would have some entitlement to a minimum of some of the records for that inmate to understand the context of what the disciplinary findings were on both sides of that conflict.
And the disciplinary findings are in the records that have been provided?
For both inmates?
Yes. I'm fairly certain, and I can look that up.
And would it be possible for us to get some idea of whether or not that the other people were involved, what their sort of overall disciplinary record looked like over the course of time they were there? If that's going to suddenly be a major issue?
It seems to me that the relevant issue in this case is was there an altercation? The fact that the other person involved in that also had a violent disposition, I think, is... I'll
tell you that he's in jail right now for capital murder. So they're similarly situated.
I'm not sure what more needs to be said.
We'll do our best to. I mean, we had some idea, Your Honor, that Mr. Shellhorn would be called today because there was a reference to our witness yesterday and that he was male, and so we were able to sort of ascertain that that was one of the upcoming issues for this morning. So this other issue is one that we are doing our best to confront and deal with as best we can this morning.
Right. Yeah. So I think that if there is a eyewitness to the encounter that the state wishes to talk about the post-arrest encounter, then that would be admissible to the extent that it goes to the peaceful character or the lack of violence. That
Judge, more important, that is an important component. More importantly, one witness specifically said he is a loving, kind, and respectful child when he was 17, 16. I would submit that the disobeying orders, telling people I don't give a F and slapping a tray out of their hands would go to their mitigation and rebuttal of that. So there's the issue of the altercation, but also we've heard lots of testimony about how well he does in a structured environment, and I would submit to the court that there's probably no more structured environment than jail or prison. And so I would ask, again, if we have those witnesses available that have eyewitness testimony, not only as to the assault issue, but also to the disrespect. And we may not, so I'm working
all
on it.
right. And again, you would have eyewitnesses to that conduct.
Assuming we have that, yes, but I would submit that those would be things that would be relevant and in rebuttal to the testimony, or excuse me, the testimony of other witnesses.
I agree.
Okay. Thank you.
All right. So let's. Are you prepared to move forward with the post-release supervision? All right. So I think we've got a clear ruling on that. That witness is here, prepared to go forward. All right.
Yeah, just one.
Yes.
Judge, we can proceed at this time.
All right. Let's bring jurors, please. Welcome back, ladies and gentlemen. Thank you for your patience while we dealt with a couple matters that we had to deal with outside the jury's presence. I believe we're ready.
There may be one additional, and I wouldn't ask the court to ask the jury to leave if this wasn't important.
All right. So you have one more matter you need to bring to my attention.
That just came to my
And it
attention.
just came to our attention.
So ladies and gentlemen, I'll ask you to step into the deliberation room. Recall all the rules I've given you. Please leave your notebooks and your chairs.
Former Officer Shellhorn had indicated that he knows juror number 12. They are in CrossFit together, and so I don't know if it's appropriate. As soon as he told me that, I thought I needed to bring it to Your Honor's attention. And I thought he was on the list that we said earlier. I know we added him at one point after getting the records, and maybe she didn't recognize his last name, because I do think she said, I know a lot of police officers from my gym, but I don't know their names or something like that. So as soon as he told me that, I'm sorry to send them back out, but I wanted to bring that to the court's attention.
All right. Well, I know there was inquiry regarding familiarity with police officers and whether that would impair anyone's ability to listen to the evidence, evaluate it, irrespective of any familiarity. So I believe that that is a topic that was thoroughly covered in voir dire, and every juror that is on the panel assured us that that certainly was the case in response to many, many questions. Let me hear from the defense. Yes.
I'm sorry if I'm not having the quickest responses I would normally like to have with the issues with it. I think that one issue may be when she was asking about it, and again, I cannot remember if his name was added at that point and all, is I guess he is no longer, my understanding, either a probation officer or a police officer, so she may not have realized this connection. I do remember her mentioning several police officers that she had a connection with from her gym, and assuring us the fact that she knew police officers was certainly not going to be a factor.
But he would have been in that category.
But he's not in that category, and second of all, she did not think there were any witnesses that she knew. I mean, one possibility would be to inquire, I suppose, of her, whether that would something would cause her any difficulty and all. I'm putting that out as a suggestion without having any case law to support whether that's the proper thing or not at this time, but that is certainly a possibility. Ms. D was reminding me that one thing that we remember in talking with her is she's a relatively new person to the area, and it seemed that a lot of her social connection to the area was out of the gym. So that may be why, out of prudence, inquiring of her would at least be a possibility. We don't think that it automatically disqualifies either her or the witness, but there may be steps that should be taken given that the witness felt strong enough to bring it to the court's attention, which we do appreciate.
State wish to be heard further.
She was my juror, and I remember specifically, she was the one that said, I know them by their first name, officers by their first name, but not their last name. So I know it was inquired into with her, and she said she didn't have any issue with it at all. So I would ask that we proceed forward as we are.
I'm satisfied that there was a thorough inquiry of the matter made during voir dire, that his name was on the witness list, and that I'm satisfied that she indicated that any familiarity she has with law enforcement officers would not cause any bias or prejudice one way or the other. And so under those circumstances, yes.
I don't remember when he was added to the list, and I do think the fact that she would know him as a nurse, and because that's what he is now, I just eavesdropped earlier, so that's the basis of that he's not in any sort of law enforcement role anymore. So when she was asked about that category of people and how she feels about that category of people, this is not a witness who would have been part of her consideration and answer. And so I know that some of those classes are quite small and meet on a very regular basis, and I do think that the fact that he's testifying specifically on the issue of the appropriate sentence between, a life sentence and a death penalty sentence is those are not nothing.
And again, and we don't remember if he was on the witness list or not, and I don't know.
He was on the amended witness list that I brought down the very first day of trial.
Okay, that's satisfactory with us. We just did not remember. So we do now.
I will make some inquiries of this juror number 12. I'll bring her in the courtroom and make some inquiries into her ability, first of all, whether she recognizes, it's Officer Shellhorn, is that correct?
He was.
Former, right.
Were you a probation officer at the time?
Yes.
Yes.
All right, and first name?
Mark.
Mark Shellhorn. I'll ask whether she recognizes him, the degree of familiarity that she has with him, and ultimately whether her familiarity with him in any way would impede her ability to sit in an unbiased fashion and listen to the evidence, my instructions on the law, the arguments of counsel, and render a recommendation uninfluenced by any bias or prejudice. That's what I'm going to ask her. I'm specifically not reopening voir dire. Depending on her answers, of course, that's always a possibility, but at this stage of the proceedings, I'm not opening voir dire. I will simply make an inquiry of her and then make a ruling as to what, if anything, needs to be done at that point. So, bailiff, if you would bring in juror number 12 and ask her to come to the courtroom, please. Good morning, ma'am. Very brief questions for you. It was brought to our attention as the jury was coming into the courtroom that the next witness in this case recognized you and is familiar with you. Do you recognize the gentleman seated behind Miss Shakita with the orange tie on, reddish orange tie?
Yes, sir.
All right, and how do you recognize him?
He was a CrossFit coach at a gym I previously belonged to.
All right. Do you know his name?
Mark. I
Okay.
believe.
Last name?
I can't recall.
All right. And so tell me about the types of, the level of familiarity you have. Is he an instructor in a gym class, in a CrossFit class that you go to and participate in? Have you had coffee with him? Have you had casual conversations? Just tell me about the nature of your familiarity with this person.
Okay. Well, as of early last year, 2015, I stopped going to that gym, and I believe he no longer coaches.
Do you know what, or did you know what at that time what line of work he was in?
Field, maybe.
All right. And so ultimately, based on your familiarity with this witness, and I believe when you were being questioned by the attorneys many weeks ago now, you were asked, there was a long list of names that were given to you of folks, and you were asked whether you recognized. Do you recall whether you recognized his name on that list?
I do not, but I don't.
Right. Is there anything about your familiarity with this witness that would make it difficult or impossible for you to sit objectively as a juror in this trial, to listen to the evidence, to listen to my instructions on the law, to listen to the arguments of counsel and render a recommendation in this phase of the trial in an unbiased fashion?
No, sir.
All right. Okay, very good. Thank you, ma'am. All right, I'm going to find, based on the responses of the juror and the casual nature of her familiarity with this witness, that there is no reason to take any further action or remove this juror.
And for the record, we are not being given the right to question her further.
That's correct.
Okay. And for the record, we would like to say that we would like to have the opportunity to exercise a peremptory challenge at this point, which we do have available.
All right, that is denied inasmuch as I specifically did not open voir dire in this case.
Thank you, Your Honor.
State wish to be heard further? All right. Let's move then to, let's bring the jurors back in, please. All right, thank you again, ladies and gentlemen, for your patience. Now I believe we're ready to ask the state whether there's rebuttal evidence in this matter.
There is, Judge, and at this time the state would call Mark Shellhorn.
Please place your left hand on the Bible. Yes, ma'am. You solemnly swear the testimony you give this court shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir. Please be seated.
Mr. Cato.
Please state your name, sir.
Mark Shellhorn,
And can you spell your last name for the court reporter?
Schellhorn.
And how are you currently employed?
I am a student and I work at Wake Med and I'm employed as a CrossFit instructor.
And what are you studying?
I'm studying nursing.
Your employment at Wake Med, is that related to your nursing studies?
Yes.
Okay. And are you focusing on a specific type of nursing?
Currently I'm with the pediatric department.
Prior to going to nursing school, can you tell the jury how you were employed?
I was employed as a probation and parole officer in a CTG unit.
First of all, can you tell us is there a difference between probation and parole? Can you explain that to the court?
So probation is people that are sentenced by the court to supervision, and parole or post-release supervision is people that come out of the prison system and are then technically still part of the Department of Corrections but supervised by there's probation or parole officer, and there's a slightly different set of regulations and rules and guidelines surrounding it.
But with whether being on probation or on parole, are there responsibilities that either a probation or a parolee has to do
Yes.
in regards?
Yes.
And you said that you're assigned to the STG unit. What is that?
So CTG, it's Community Threat Group. It's STG when it's in prison. It's basically the Department of Corrections terminology for a gang unit.
Overruled.
And so is it S or C, or does it depend on your designation?
It depends on the designation. So C is for the community, S is for security, being with the prison system.
And being involved with either the community threat or the security threat group, are there additional responsibilities or additional guidelines that those folks must follow?
Yes, they will follow CTG guidelines that are specific to gang members on supervision.
And can you kind of outline those specific gang-related?
Generally, they involve some sort of curfew, not associating with known gang members, being associated in known gang areas are kind of the major criteria for those.
And how is it that a particular person, either whether they're going on probation or coming out of prison and going on post-release supervision, gets put into one of these units?
So there's a couple different options. If somebody is coming out of prison, the prisons do a validation paperwork. There's a certain point criteria that people get concerning whether they're listed as either a member or an associate. Some of it's self-admission, some of it's tattoos, some of it's the people that they hang around. As far as how they come on the CTG unit, as far as probation goes, if they have prior been on the CTG unit, they come back. We're trained to do validation criteria for the department also. So
Can you explain what that means?
Sure. So if another officer has a concern about one of their members possibly being a gang member, they will come to us. We'd conduct an interview with them, take a look at tattoos, kind of a criminal history, and just talk to the offender and make a determination if we feel it is in the best interest, or if that person is a gang member, or it's in the best interest of the department to have them supervised by a select group of officers rather than a traditional caseload.
And you said that there's validation paperwork to determine if someone is a member or an associate. What's the difference?
As far as the prison system, it depends on a point value. So you get a certain point value, you are listed as an associate. If you get a certain point value, you are listed as a member. One of the biggest criteria, but not the only criteria, is self-admission.
Okay. And in how long have you worked within the probation parole system, whether here or somewhere else, specifically involved with some sort of gang assessment?
Approximately 7 to 8 years.
Could you estimate over those 7 to 8 years how many different people you've supervised in some capacity?
Tens of thousands of people.
And you had said that one of the biggest criterion is self-validation, that is admitting themselves that it is. Is it common for folks in your experience to admit that they're involved with some sort of gang?
For the most part, it's pretty common. They like to talk about who they're affiliated with.
Objection, Your Honor. This is going beyond the scope of the lay witness.
Overruled.
I'm ready to move on.
Yep. Okay, go ahead.
Mr. Shellhorn, at some point did you become responsible for supervising the defendant Travion Smith?
I did.
And how was it that he came to you?
He was released from prison to my custody.
And do you know what he was in prison for?
I believe it was possession of a stolen motor vehicle.
And once a person comes out of probation, you talked about sort of the post-supervision release. What are their requirements while they're on post-supervision release?
So specifically with Mr. Smith, he had a curfew. He was required to make a monthly supervision fee of the amount of $40. He was required to maintain a residence. He was required to report in as necessary, not commit any new crimes. There's quite a lengthy list that is kind of the specifics and the big ones that people tend to have difficulty following.
Okay. And with respect to when he came to you, and do you go over all of these rules, whether it's the general ones that you just described or the more specific ones?
So yes, ma'am. He, when he gets out, he assigns his post-release supervision paperwork. I don't recall if I was the officer that would release him from custody of prison or if it was a different officer, but they will actually go through. I will have my experience. I would have somebody read over it, then I would go over it with them again, ask them if they had any questions associated with what they complied. When they come into this is done at the facility. Then
In the prison facility?
Yes, ma'am.
Okay.
Then when they come into my office, I again kind of go over some more details, specifically about curfew and for this defendant, his CTG conditions.
And those are the ones that you said were specific to not hanging out with known gang
Yes,
members
ma'am.
and things of that nature. And did he appear to understand the conditions as you relayed them to him personally?
He indicated to me that he understood. He signed the documents saying that he understood.
When he was released from prison, do you recall about what time frame it was?
I believe it was sometime in January of...
2013?
Yes, ma'am.
Okay. And where was he living once he was released from prison?
He was living with his father.
When someone goes to live at someone else's house, that is not their own residence, are there any restrictions or requirements about following the house rules?
Yes, ma'am. So essentially, his father is the one that allows him to stay there. So it's a courtesy to live there. He does not have to live there. So his father, there's a post-release supervision plan that gets submitted. Mr. Smith submitted it to his father's house. We as officers went out, verified the residence, informed the father of some criteria such as Mr. Smith's going to have a curfew, warrantless search conditions. We can search the house for any reason that we want to, and we will.
And just to be clear, so you're telling his father, we can search your whole house if
Yes,
he's
ma'am.
living here? Okay.
And they have to comply or allow that from Mr. Smith or any probation or parolee to reside at any residence.
And did he appear willing to allow his son to come live there?
Yes, ma'am.
How often would you see, for example, Mr. Smith after he was released?
So he came to my office just based upon some of the situations that Mr. Smith and I had. I saw him a little bit more frequently, about every 2 to 3 weeks, and then I would get out to his house, try to get out to his house on a weekly basis. He was also supervised at that time, or had a surveillance officer who would go by and do curfew compliance checks.
And what do you mean by that?
Would go to Mr. Smith's house after his 6 p.m. curfew to make sure he was at his residence.
And the surveillance officer, is that someone that you have communication with in terms of, I've gone to the house, he's there, or I've gone to the house, he's not there?
Yes, ma'am. We communicated via email and via telephone, and also his notes auto-populated on my system, so I could go in and see if Mr. Smith had a missed curfew or if a curfew check was done.
And did you yourself have occasion to go to the defendant's father's home personally to see on occasion if he was there?
Yes, ma'am.
What happens if someone is not at the residence when they're supposed to be? That is the 6 p.m. to 6 a.m. curfew.
Generally, they are given some type of warning. We understand possibly there's reasons if they're late, 15 minutes late, say maybe he was looking for a job. So we give them some sort of leeway. There's no predetermined amount of curfew violations, but after a determined number of curfew violations, we do a violation report to the parole board and make some sort of recommendation as to other sanctions that may be placed on a probation or parolee, from continued supervision to electronic house arrest to this person should be arrested and their parole should be revoked.
And just so I'm clear, if perhaps one curfew had been violated, you kind of give a warning and
Yes,
remind
ma'am.
them of
We
the
kind of have a
curfew.
discussion as far as what's going on.
Yeah.
Let's get things back on track.
Okay. And prior to actually taking out a violation of his post-release supervision, would you have had those conversations with him about that?
Yes.
When you would go out to the house yourself, did you have an opportunity to watch the defendant and his father interact?
Yes.
Did he, that is the defendant, ever complain to you about being mistreated by his father? Any concerns about how his father treated him?
So there was no real concerns about how his father treated them in my experience with him. There was some concerns. Mr. Smith felt that there was an issue with a child that Mr. Smith brought to the home. There was some concern from Mr. Smith about his father and his father not being accepting of the child, possibly being his own. So I had conversations with Mr. Smith. I had conversations with Mr. Smith's father about the situation to try and mitigate the issue.
And when you say that there were some concerns about a child, did you actually have conversations with both dad and the defendant?
I did.
Okay.
We talked about both of that. Some other things that kind of came up into contention were Mr. Smith leaving after curfew, so either myself or the surveillance officer would stop by, and Mr. Smith's father would tell us then at a later time in the night after one of us stopped by that Mr. Smith would leave or come back in the morning, so be gone all night. Or some characters or individuals that Mr. Smith was having or would come over to the house.
Objection, confrontation.
Members of the jury, I'm allowing this testimony not for the truth of what's being said, but for the purposes of explaining the relationship between the father and son and things that this officer did in response to information he received. You're not to consider the truth of the statements that are made out of court because they're not being made under oath, but you may consider them for the limited purposes for which I'm allowing them. Go ahead, sir.
And you said, I think you were saying that there were characters coming over to the house?
Yes, ma'am. Individuals that were coming over the house that Mr. Smith's father did not want him associating with. The comments that he made to me revolved around the fact that he did not want those individuals in his house around his other children, and also that he did not feel that those individuals were a positive influence on Mr. Smith.
And specifically, did he refer to those individuals?
He referred to them as gang members.
Okay. And when, for example, if I were to go and be on supervision and we're living at my family's home, does the family get to make the decisions about who comes to the home?
Yes, ma'am.
Versus the probation?
It's their house.
Okay.
I cannot make rules and regulations about somebody's house that I don't reside at, and that's one of the reasons when we go there that we have to explain, hey, we're going to come to your house, we're going to search your house, and if you don't like that person can't live here, that's a decision they have to make.
And would that have been information you would have shared with his father?
Yes, ma'am.
And when he would come to you with the concerns about his son being gone for the night or people coming to the home that he wasn't concerned about, you said that he was worried about those people being around the other members of the family?
Yes, ma'am.
Was he worried about the defendant hanging out with
Yes,
them?
ma'am.
And why was that?
Just, he didn't...
Objection. Again, confrontation.
Overruled. Again, members of the jury, I'm going to caution you that this information is being received solely for the purposes of what this officer did and it's as probative of the relationship between father and son at the relevant time period, and you're to consider it solely for that purpose.
He did not feel that the relationship was beneficial for Mr. Smith to maintain staying out in the community and abiding by his supervision and just continuing to abide by the rules of society.
Was he worried he was going to get in trouble?
Yes.
And when he would bring these concerns to you, how soon after you started supervising him would you say Dad brought those concerns to you?
I think they were brought, if I recall correctly, they were brought pretty quickly. I'd say at least within the first month.
And as a response to being concerned about the leaving after curfew and the association, did you make some decisions about changing the status of the defendant's post-supervision release?
Yes, ma'am.
And can you tell us about that?
Based upon his violations, I completed a violation report and recommended to the parole board that he be placed on electronic house arrest.
And why would you do that?
To make sure that Mr. Smith was not leaving, this gave me a way. He's essentially put on an ankle bracelet and monitored via our surveillance system, so I can keep track of where Mr. Smith is 24 hours a day, 7 days a week. And it just gives me a little bit more, I guess, structure over Mr. Smith's environment.
prior to submitting that violation report and recommending that he be put on electronic house arrest, had you had conversations with the defendant about that's what you were going to do?
Yes,
And did he indicate he understood that?
he did.
Did he continue to violate before you, I guess here's a better question. Once you noticed that he might be in violation of his probation, did you tell him what the next step might be?
Yes.
And did he continue to
He did.
violate the
Yes,
probation?
ma'am.
Once he was put on electronic house arrest, is the curfew still in place?
So once he's placed on electronic house arrest, he's to be in his house 24 hours a day, 7 days a week, and we essentially create electronic bubble around the house. So anytime the offender would leave that bubble, we would get an alert. Anytime there was we called it a strap tamper, anytime there appeared to be any sort of tampering with the device, we got an alert. Anytime the battery ran low, we got an alert.
And when you would get an alert, for example, what would you do?
So it would depend on the alert. If Mr. Smith would leave his residence and then hop right back in, we just have a conversation during our normal interactions of, hey, just don't leave the front yard. If he was out, sometimes I would give him out time to look for work, and I believe he was pretty compliant as far as coming back in. Occasionally, I think he had 1 or 2 issues with the bus system that the bus took longer. We just have a conversation of, hey, you got to keep me in the loop as far as what's going on, because that's what you're required to do.
And in addition to the curfew that you had mentioned and sort of complying with the regular rules of probation, not getting into trouble and that kind of thing, were there any specific like classes or things like that that he was supposed to do?
So he had to complete the organization's called task assessment, and that was based upon a violation of a positive drug screen that he had with me. Once I submit out a referral, I give him a couple days and times that he has to report to this assessment. That was his main thing to do.
And you had said that often you will talk as a member of the CTG unit about some folks will self-validate. Did you have a conversation yourself with the defendant about any gang affiliation?
We did. I was actually, he didn't have a ride to my office, so I was giving him a ride back home from my office, and I was just inquiring a little bit as far as what was his position on, why was he on the CTG unit, what was his thing. He admitted to me that he was a member of a blood set, the Pyru.
And when you say a member of a blood set, for members of the jury who may not be familiar with that, what does that mean to be a set?
So the blood is a larger organization. A set would be a unit of that organization.
And did he have any hesitancy in talking to you about that?
He was pretty upfront about his membership. I asked him some further questions to try and get some more information just based upon personal knowledge and intel that I can share with the rest of our department and unit. He was pretty vague in what he would give me. He wasn't very specific as far as...
Is that uncommon?
No, that's pretty common.
Okay. Was there a period of time when you first started supervising him until until the incidents where here happened, where he didn't reside with his father?
So there was a short period of time where he did not reside with his father. Essentially, his father kicked him out of the residence. I believe it was for being disrespectful and having some issues with his siblings. This was when he was on house arrest, I believe. He was... I instructed Mr. Smith to reside at the Wilmington Street shelter until he had another residence to go to. Myself and the surveillance officer, I believe, completed some curfew checks at the shelter, and the shelter did not have him listed there, which means he was not there. A short period later, within the week, he was back at his father's house until the incident where he let the monitor die and cut off his bracelet.
And so there was a period of time where his father and him had gotten into an argument about being disrespectful. Did his father let him come back to live with him?
Yes, his father did let him come back.
And I want to talk to you about when you stopped supervising him.
Yes, ma'am.
How was it that you stopped supervising the defendant?
So, I formally stopped when he was arrested for his current charge. As far as when I stopped supervising, he stopped complying with me.
Yeah.
Would have been the middle of April. His father had kicked him out of the house. I had gotten a call from RPD. Subsequently, his father wanted to kick him out of the house. RPD told his father, you can't kick him out of the house. He's on supervision. Anyways, I was the one who got called. I informed RPD and his father that, yeah, kick him out of the house if you don't want him there anymore.
And is that what you would have told anyone?
Yes, ma'am. I can't make somebody stay at that residence if they don't want to stay there. So I had Mr. Smith. He got kicked out of the residence. I told him to report to me 8 a.m. the following morning. I believe he came in around 9:30 the following morning. We had a discussion of, hey, look, clearly your father's residence is not working. Father, you or him, you need to find a new place to live. If it's a shelter, fine. If it's a friend's house, as long as they comply with all of the requirements, fine. I gave him till, I believe, 11:30 that morning to find a residence. I hadn't heard anything by around 4 p.m. from Mr. Smith. I called BI, who was the company who he had our electronic monitoring equipment through. They said that his unit, Mr. Smith's unit, had died, meaning that it was no longer held a battery charge.
How long does it stay active?
It's generally active. It depends on how much movement there is. Anywhere 24, 48 hours. We tell everybody, plug it in for 2 hours a night and you will have no issue with the charge. So it had been dead for a period of time. We had numerous discussions when he left the house, make sure you charge your equipment.
Okay, and I would say, was that something you would
Yeah,
remind him?
and we talked about it. I think he used to prop his foot up and play video games when he was at the house, and that's how he charged his equipment. So he knew he had to charge his equipment. When I didn't hear anything and his battery had died from BI, I went out to the residence because that's what that was our policy, that was his last known residence. That's where I went. Was informed by his father that he was no longer residing there. I didn't have a contact number for Mr. Smith. I didn't know where he was staying, and based upon that information, I could not track him electronically anymore. I submitted a violation report to the parole board and recommend that a warrant be issued for his arrest.
And to your knowledge, was that done?
Yes.
And you had said earlier that you had had some discussions between the defendant and his father about a child that potentially might not be theirs. What did you do in an effort when they would come to you with their concerns?
So there appeared to be, again, it's 3 years ago, so I'm going on memory, but there appeared to be, Mr. Smith brought home a child that a girl said was his. Mr. Smith's father did not want him to take acceptance of this child without a paternity test. He kind of felt like Mr. Smith was being duped and didn't want him to be on the hook financially and for responsibility for for a child that wasn't his. I basically talked to both sides. Talked to Mr. Smith of, hey, look, your dad's looking out for your best interest. He give him the benefit of the doubt on this one. A paternity test probably isn't a bad idea. It's not going to hurt anything. I talked to his dad about, hey, your son is trying to step up and be a man to a child that may be his. So I guess I kind of played both sides of the fence on that one to try and alleviate the issue. Ultimately, I talked to both of them that, hey, a paternity test is the way to go. Figure this out. Figure out whether it's yours.
And ultimately, the leaving the residence, how did you know that the defendant was no longer allowed to reside in the residence with
So his father, when I spoke to him on the phone the night before when RPD was called, so I spoke to RPD and his father, he said he's not allowed to stay here anymore. And then the following day when I went over there after Mr. Smith's equipment had died.
And after the equipment dying, did you ever get the electronic monitoring
I did not.
bracelet back? Do you even know where it is to this day?
No, I have no idea.
You had said if there's a tamper alert, if someone cuts a bracelet off, for example, what happens?
So we would get an alert that there was a tamp alert. That only happens, though, if there's an active battery.
Okay, so if it was dead.
So if it's dead, they can cut it off, and we have no idea.
And after the time when you saw the defendant in your office the next day after his father had said he could no longer reside there, did you ever see him personally again?
I saw him when he was arrested on his current charge at Wake County Jail. We held our final violation hearing.
Okay. How often or how many times would you estimate you had an opportunity to see the defendant and his father together?
A half dozen.
Okay. And in looking at them, did you have an opportunity to see how they interacted?
They appeared to get along fairly well. Clearly there was some contention as far as Mr. Smith's behavior. In my experience, anytime a family member lets somebody stay at their house there's clearly some sort of, I'll use a word, caring. It's a pretty big invasion of anybody's privacy.
Sustained.
Well,
Joe's to disregard.
let me ask you this. You had said that you felt like that at one point that you had made the comment that you felt like his dad was looking out for his best interests. Judge, he's described an
Right,
opportunity.
I'm gonna allow the line of questioning, but I'm not sure I recall those specific words, so as to form, but perhaps if you could just, I'll sustain the objection as to form, let's put it that way.
Did you not say earlier that you felt like the dad was looking out for his best interests?
I did.
Okay. And why do you say that?
Overruled.
Because he didn't want his son to get stuck in a situation that could negatively impact him in the future as far as the child goes. I also, in my opinion, I felt that the father letting us know that he was leaving after curfew was a way to possibly try and...
Overruled. I'm gonna,
I can ask it this way. Were there other things that indicated, that form your statement that he was looking out for his best interests?
Yes.
And what is that?
The fact that he let him reside at the residence to start off with, and the fact that he was as involved with contacting probation when his son was not doing what was right, to me showed that he wanted his son to go somewhere and not continue the path that he was traveling down.
all right. Overruled, I'm gonna allow it as an opinion based on this, what he observed.
And you had described earlier the Piru as a subset of the blood gang. Are there colors that are associated with particular gangs?
Generally, it's red.
Sustained. Cross-examination.
Yes, sir. Good morning.
Good morning.
As part of preparing it, were you aware of Michael Clark's criminal record?
Of,
Mr. Clark's criminal record?
no, sir.
His past days in prison?
No, sir.
And you said that you knew that he was caring for his son. One of the reasons you knew he was caring for his son was that he would report to you when he was violating curfew.
Yes, sir.
And that you talked about the conflict that he had over the fact that Travion was bringing a baby home.
Yes.
A baby that Travion believed was his son.
Yes.
A baby who Travion was trying to help care for.
Yes.
And his father was upset about that.
Yes.
His father was upset that Travion was trying to stand up and do something for the child he figured was his son. Is that correct?
I don't believe he was upset that Travion was trying to care for a child that he believed was his son. I believe that he was upset based upon the fact that Travion was taking with blind faith that this was his child. I believe that Mr. Clark wanted Travion to inquire a little bit more as to the validity of this claim.
Okay, and the night that he, and if I, oh my God, sorry, Mr. Stroller. Are we on number 20? And all, and I'm showing you it's been marked for identification.
Okay.
This is appendix number 20. Can you take a look at that and see if you're familiar with it?
Sure. Yes, sir.
And these are forms that you filled out?
Some of them are filled out by me. Others of them are filled out by other
I
officers.
want me to show you what's marked on this page.
Yes, sir.
Ask if you are familiar, if this is one that you had filled out.
Yes, sir. This bottom one?
Yes.
No.
That was not one that you filled out?
No, sir.
Do you know who, somebody else in
It-
the office filled it out?
Yes, sir. It says contact officer would be Donald Barber.
Okay. Thank you.
You're welcome.
One of the things, but are you aware that when he was kicking him out of the home, the complaint that day was that the baby had been brought home for the weekend?
Yes.
And that Mr. Clark had said that he brought home a baby that he wasn't even sure was his.
Yes.
And that had been what had sort of instigated this final falling out.
Yes.
And Mr. Clark thought that raising a child that you're not sure is yours would be a burden.
I don't know what Mr. Clark's rationale was. The conversation we had was not that Mr. Smith was raising the child, but just that Mr. Smith hadn't asked for a paternity test or anything like that to verify that the child was actually his.
And if you're not sure, what? And then raising a child without making sure that it's yours could cause you to do financial hardship that you would otherwise not have.
Yes.
You said that he did have a conversation with you in which he admitted being a Piru?
Yes, sir.
And would it surprise you that he also, when the police were interviewing him about this, that he also mentioned being a Piru?
That would not surprise me.
He'd been kicked out. Did Mr. Smith report the next day?
Which time are we talking about?
The second time?
Yes, sir, he did.
Reported to, and you told him he had to get a new residence
Yes, sir.
by noon?
Yes, sir. I believe it was 11:30, but
11:30. But you would have given him to noon?
I would have given him honestly, I would have given him till 5 o'clock that day.
To 5 o'clock that day. But what you told him was 11:30?
I did.
All right, thank you. A home that had a landline was required?
No, it didn't. He didn't have to have a landline.
Okay. But it had to be-
All I needed was an electric outlet so he could charge his unit, and he knew that because the Wilmington Street shelter, he doesn't have access to a landline. All he needed to do was plug in his unit.
All right. Somewhere in Wake County?
Yes, it didn't even have to be in Wake County. I could have transferred him to a different county if he wanted to.
Okay. You'd have to do the transfer to do that.
I would have. Honestly, it gets done every day. It's not a huge.
But you had told him by 11:30?
Yes, sir, I did.
All right. Thank you. I have no more questions.
Mr. Keita.
Briefly, Mr. Shellhorn, you had said that you would generate narratives, and then I think you said, and this may not have been your word, that the other folks would auto-populate. Does that mean you have access to their narratives?
Yes,
and their
ma'am. So the records that I got shown, that populated into my system every day, so I had access to those records. We also had a little screen, it said CC, which would be curfew contact. We had different codes associated with whether Mr. Smith was home, whether he was not home, so I would be able to go in and see a date, and if it's CC1, it meant that he was home. If it was a CC3, it meant nobody was home. So I could see it and then go in and inquire further.
May I approach Judge?
Yes.
I'm going to mark my copy of that as S5, but it's the same document you were just shown by the defense, specifically pointing your attention to that date where we're talking about the police being called.
Yes.
Have you had a chance to at least review the narrative of Officer Barber?
Yes.
And again, was that part of auto-populated into a record that's ordinarily kept in probation?
Yes.
And on there, if you need to refresh it, were there other concerns about the baby, not just that he was being brought home, but supervision of the child?
So it appears to me, from reading this, that the defendant had some people come over to the house and left the child inside for a prolonged period of time. I'm assuming with the father. I don't recall who the child was with. Mr. Smith was not with the child, and the father had some concerns about, A, why is he bringing this child into the house that he doesn't know is his? B, why am I the one taking care of it when he's taking on this additional responsibility?
And did he point that concern out according to the note to Travion, that is, that the baby's being unattended?
Yes.
And what was Travion's response?
Basically, he didn't come back in.
I don't have any further questions. Glad my approach together.
Yes. Mr. Brown, do you want to leave S5 or defend
Yes,
it?
if it'll be possible to have S5, if you have a chance to review it. So you're familiar with what, I'm sorry.
You're talking about that same note?
I'm talking about the same note, yes, thank you, ma'am. So you see the note, same note?
Yes, sir.
And so you're familiar with what it says?
I am. I have it here in front of me.
Okay, and this was what the other officer said, but it says, defendant not at home, and let me ask you if I'm reading this correctly, spoke with defendant's father, stated the defendant had brought home a baby this date, stating that he was keeping it at the home for the weekend. Defendant's father pointed out that defendant is not even sure if it's his own son.
Correct.
If it's his son. Later in evening, male and then female failed to come, a friend came to house, and defendant went out to talk with them, leaving baby inside. Defendant's father went outside once to tell defendant to come in and look after baby. No response. Went out a second time and told defendant that he was going to call the baby's mother to come pick him up. Defendant became irritated and disrespectful. Defendant's father called the Raleigh police. When the police arrived, they informed the father that since defendant was on house arrest, that they could not force defendant to leave. Defendant's father called P.O. Is it Shellhorn?
Yes, sir.
All right. P.O. Shellhorn stated that if defendant needed to be kicked out, then so be it, and that it did not matter if he was on EHA or not. Defendant left the property, and his father has not seen or heard from him since. That's what the note says.
Correct.
Okay, thank you. Any further questions?
Thank you, sir. You may step down.
Be released.
Any objection?
No, sir.
All right, sir, you're released from your subpoena. You're free to go. Further evidence for the state?
Your Honor, at this time, the state would call Ms. Grace McGovern to the stand.
Place your left hand on the Bible and repeat it. You solemnly swear the testimony you give this court shall be the truth, the whole truth, nothing but the truth, and nothing but the truth?
Yes.
Thank you, ma'am. Please be seated.
Mr. Waller?
Ms. Governor, good morning, ma'am.
Good morning.
Will you please state your name for the court?
Grace McGovern,
Can you spell your last name for us?
McGovern.
Ms. McGovern, what is your, are you in school now?
Yes.
Okay. Tell us a little bit about where you're in school.
I'm a senior at East Carolina University, and then currently I have to do an internship to graduate.
And what are you studying at East Carolina?
Criminal justice.
And tell us a little bit about this internship that you have to do as part of your program.
I'm with the district attorney in Wake County.
So you're working with our office?
Yes.
Okay. And when did you start working with our office?
January 4th of this year.
And have you been working with myself and Ms. Shakita in this trial?
Yes.
And doing errands and research that we've asked you to do?
Yes.
And Ms. McGovern, have you been present throughout the course of this trial?
Yes. Since day one. Of jury selection.
Assisting us since jury selection?
Yes.
Now, Ms. McGovern, as part of what we've asked you to do, we asked you to look on social media, different websites to investigate different witnesses and such.
Yes. Multiple social media.
And does that, one of those social media websites that you've been asked to look at, does that include Twitter?
Yes.
And are you familiar with Twitter?
I am.
How old are you, Ms. McGovern?
I'm 22. I will be 23 this year.
Okay, and as part of being a 22-year-old, do you spend time on Twitter?
Yes, occasionally.
All right. Tell us a little bit about kind of what Twitter is, what you do on there.
Basically,
you have followers, so your friends, anyone, it could be up to 100, celebrities like 1 million. And you just post your thoughts and what's on your mind that day and anything.
And do these tweets come out live, or are they in a public domain?
Oh yes, they're live. They have like a timestamp, for example, like this person posted an hour ago, and everyone can see.
And is there any restriction as to who can see what information you're posting? Do you have to be a follower or following somebody, or?
Not necessarily. I think on Twitter you can do private, but there are tweets that anyone can see. Like if I don't follow someone, I can go to their page and see if they tweeted, if they, in a retweet, like someone else tweeted they want it on their wall. You can see pretty much anything.
And do sometimes people get involved with discussions about different issues that are happening in the world?
Yes. To reference something, say I'm going to Ben and Jerry's. To reference a place, I would do hashtag Ben and Jerry's or hashtag, and that would be like a trend. So if you were to search hashtag Ben and Jerry's, you would see everyone who had hashtagged that certain topic.
And kind of another example of a big event that happened recently was the Super Bowl.
Yes.
And if people wanted to get on Twitter and talk about the Super Bowl, how would they do that?
They could do hashtag Panthers, hashtag Super Bowl 50, I think. I'm not a football fan. Hashtag Panthers, or I think there was hashtag Keep Pounding or something. You can search that and see everyone.
And if somebody does a hashtag Super Bowl, can anyone go on there and see that a certain person is talking about that issue?
Yes, their username and name would pop up, and you can see their actual tweet.
Ms. McGovern, thank you. Yesterday, were you present in the courtroom when Ms. Christina Love testified?
I was.
Okay, and do you recall kind of her emotions that she exhibited while she was on the witness stand?
I do.
What did you see her doing?
Crying would probably be the biggest. Some of the nonverbal was having her head down, covering her face.
And after she testified, were you asked to see if she posted anything on Twitter?
Yes, I monitor social media as I do.
May I approach the witness, Your Honor?
Yes.
Governor, I'm going to give you what has been marked for identification purposes as State's Exhibit S6. You'll take a look at those three documents and tell me if you recognize them.
Yes.
What do those documents appear to be, ma'am?
Tweets.
And can you, they appear to be a Twitter feed?
Yes, a Twitter feed.
And can you tell whose Twitter feed that is?
Yes.
Whose Twitter feed was that?
Miss Love's.
Okay. Make sure you
Objection, Your Honor.
I'll allow foundation as to how she has made that conclusion, but we'll need that foundation
Yes,
first.
sir. Yes, sir. And make sure you speak up, Mr. McGovern.
Sorry.
I'm going to go to page 2 of this document. Do you recognize who that lady is?
Yes, I do.
All right. Who is that lady?
Miss Christina Love.
Okay, and is that the same lady that you saw testifying here yesterday in court?
Yes, I did.
And does it appear that she has the same hair color, same scarf?
Yes, that's how, that was one of my foundations of.
And in the background, can you see, Ms. McGovern, where it appears that she is in relation to the courthouse?
She's standing directly in front of it.
And again, make sure you...
She's standing in front of it, the building. You can see the building right behind her.
You mentioned a moment ago that people have, I guess, name handles. Is that right? How do you identify yourself on Twitter?
You have an @ and then your name, and then if someone were to tweet you, you put @ their name, and then it goes to them directly.
So, for
That's
example,
what you're asking.
you don't have to give us your Twitter name, but if I had one, would it be @Jason Waller, and that would identify myself?
Yes.
Now, do I have to put my name in as my identifying name on Twitter, or can I say whatever, call myself whatever I want to do? Panthers fan 101.
Yes, you can do whatever name.
Okay, so it doesn't have to be your specific name.
Yes, it doesn't have to be your name.
Now, her name has been
Objection, Your Honor, that's like to be heard.
Overruled. I'll note your objection. Again, just abide by my prior orders.
Yes, sir. I don't want you to tell me any names that you discovered with Ms. Love. Do those names appear to be redacted in this document?
Yes.
Okay. Now, but looking at the same, at page 2 of State's Exhibit S6, would that name that appears to be whited out, would it be associated with that picture?
Yes, it would.
Okay. And then you mentioned a moment ago that people can discuss topics on Twitter. My example was the Super Bowl. But on page 2, does it appear that there's a hashtag topic there on Twitter?
Yes, the hashtag is Travion Smith trial.
And so, again, using that hashtag, would people be able to discuss the Travion Smith trial on Twitter?
Yes, once you put that hashtag in the search, you can see all the thread of this hashtag and everyone who names it in their tweet.
And does it appear in looking at the 3 different documents attached to S6 that they show kind of a feed or a chronology of what Ms. Love, or this person that you recognize as Ms. Love, said regarding this trial?
Yes.
You say yes?
Yes, I did.
Okay. And when did you print this document out for us, Ms. McGovern, or did you make us aware of this document?
I made it aware to Ms. Chiquita specifically, and then you came in.
And Ms. McGovern, do those copies of that Twitter feed appear to be a fair and accurate representation of what you saw on the internet, the social media site?
Yes.
And other than the redactions, any changes or alterations to that document?
No.
Your Honor, at this time I would ask to introduce State's Exhibit S6 into evidence.
Objection for reasons previously stated and foundation.
Overruled. S6 is allowed.
Thank you, Your Honor. And Ms. McGovern, specifically as to the first page, and I believe you mentioned a moment ago that there is kind of a timestamp as to when people are posting. Is that right?
Yes.
Can you tell us a little bit about that, how that works?
So once you click tweet, you write whatever you want, click tweet, it'll say 1 hour or 12 hours or 13, however long that person tweeted. So timestamp.
If I tweeted something right now, it would show...
It would say now.
Okay. And in a couple minutes, it would say 2 minutes and so forth?
Yes.
Looking at State's Exhibit S6, when this person that you've identified as Miss Love from the photograph, this first tweet that she sent out, what time was that? Or how long ago did that happen, I should say?
12 hours ago.
Okay. So when was this document printed out, do you recall, Ms. McGovern?
9:07, because I checked my watch when I had a text message.
Okay. So 9:07, again, I know I'm right
Okay.
in front of you, but make sure you speak up to all the jurors, okay?
It was approximately 9:07 because I had checked my cell phone for a text saying go to the printer.
So from 12 hours, at 9:07 a.m., this tweet would have been sent out 12 hours ago.
Yes.
The first tweet that we have here, it appears it says appreciate the love, and there's I guess an emoji there.
Yes.
What's an emoji?
And a little picture, like a smiley face, a basic smiley face, yellow smile. And an emoji can depict certain emotions, I guess. You can say, can I say what this is?
Yes, ma'am.
In this example, appreciate the love. The emoji is a smiley face, but kissing with the heart.
And then this first tweet that she sends out, is it a response to what someone else, a message that someone else has sent her?
Yes, so someone else tweeted her, said, can I say it?
Yeah.
Hope everything went okay for you. So she had retweeted and wrote in response, appreciate love, and then the kiss face. So I'm a grammar fanatic, so there's no comma, so I would just, if reading this, I would assume she called that person love in a way and then gave him a kiss face.
So whoever this @meet, Goddy, Gotti, sent this message to Miss Love, and that was her response.
Yes.
Okay. I want to go to, you said that was 12 hours ago from 9:07, 13 hours ago. What was Miss Love's tweet at that time?
I'm ready for baby to get off sad face, so almost crying but no tears is this emoji.
Page 2, what did she tweet at that point?
With this tweet, she included the picture, always riding for baby bro, #Travion Smith trial with a heart next to it.
Right. And then this is the photograph that you described earlier of Miss Love.
Yes, in this photograph, you can see the Justice Building right behind her, over her shoulder.
Okay. And would this photograph be called a selfie?
Yes.
Yeah, it looks like she took it herself.
Yes.
Okay. What's Miss Love doing in that photograph?
Smiling, looking down at the camera. Yeah, just looks happy in a way.
So she's smiling in that photograph?
Yes, 15 hours ago.
And that was what my next question. According to this tweet, how long ago was that tweet made?
15 hours ago, so from 9, approximately 15 hours prior, she had posted this picture.
And then on to page 3, kind of walk us through the conversation there.
So this also is taken 15 hours, so around all the same time. Do you want me to read?
Yeah, and we'll just start with what did Miss Love say in that tweet on page 3?
Well, in this tweet, someone had tagged her, praying for y'all, and then a emoji like so, putting hands together. She responded to them, thank you, baby, ! Kissy face. The next two tweets, it looks like they kind of come together, but you can only add 140 characters. So sometimes you have to post twice in a sentence. So in the bottom one, essentially, it says, everyone keeps hitting my line telling me I'm on the news, like I wasn't aware, LMFAOOO.
And if you'll finish kind of what she said, and then we'll go back to that.
And then, but thanks, ... But thanks for all of the prayers and kind words from everyone. Heart, swear I love y'all.
You mentioned in that kind of the last tweet on page 3, that is the first part of that sentence, everyone keeps hitting my line telling me I'm on the news like I wasn't aware. And then you said it says LMFAOOO.
Yes.
As part of your experience on Twitter, are you familiar with what a sequence of letters like that means?
Yes.
Right. What does LMFAO mean?
Objection for reasons previously stated.
Am I allowed to curse?
Yeah, whatever it means.
Okay. It says laughing my fucking ass off, but since there's 3 O's, she exaggerated.
Objection, Your Honor.
Sustained as to what, just limit it to what your understanding of that would be without speculating on what she meant by including additional O's.
Okay.
And I already asked the question. Ms. McGovern, based on your experience with Twitter and being a member of the Twitter community, what does LMFAOOO mean?
Laughing my fucking ass off.
And the fact that she's put 3 O's behind LMFAO or LMFA, what does that mean to you based on your knowledge of being on Twitter?
She's a,
Overruled as to your opinion as to what that means in the vernacular of Twitter.
so she exaggerated this. My observation is, or opinion is she was being sarcastic because that's what I do.
Objection.
Sustained.
Oh, okay.
Thank you, Mayor. No further
And move to strike, Your Honor.
Juries to disregard. Anything further for this witness?
No.
Cross-examination.
Just briefly, so Twitter is a very casual medium
Yes.
for
Casual.
short, off-the-cuff thoughts.
Yes.
That's part of why you can only put a few words in each one.
Yes, 140 characters.
And you were asked to monitor Travion's sister's social media.
I can't hear you.
You were asked to monitor Travion's sister's social media?
I was asked to monitor all of the Travion Smith trial on social media. So hers among other people did that hashtag, which was on that trend.
I don't have any other questions.
All right. Anything further, Mr. Wells?
No.
All right. Thank you, ma'am. You may step down.
Your Honor, we would ask to publish S6 at this time.
All right. Let me review
Yes.
has counsel reviewed?
Yes, we have
All
reviewed
right.
it.
Let me take a quick look at it. Exhibit. So, ladies and gentlemen, we'll take a 15-minute recess till 11:30, a little bit shorter than 15 minutes, but please recall all the instructions I've given you throughout the trial. Leave your notepads in your chair, gather in the deliberation room at 11:30.